Welcome back, dear students, once again. Today, in this lecture, we will understand the concept of right to education under Indian Constitution. As all of you know that Article 21 capital A has been added in our Constitution, and thereafter the Right to Education Act 2009 has also been enacted and implemented to ensure the right to education. This right of children to free and compulsory education act or right to education act is an act of parliament enacted on 4th August 2009, which describes the modalities of the importance of free and compulsory education for children between age group of 6 to 14 in India. See, there are two words in this act. Education must be free and it has to be compulsory. If it is free only and not compulsory, or vice versa, it is compulsory but not free, the purpose of the act will not be fulfilled. So, right to education became a fundamental right of every child when this act came into force on 1st April 2010. And on the same date, Article 21 capital A was added in our Constitution by Constitutional 86th Amendment Act 2002, which was enforced with effect from 1st April 2010. So Article 21 capital A and the Right of Children to Free and Compulsory Education Act 2009 came into force on the same date, because their area of operation is also almost same. If you see the chapter of fundamental rights and fundamental duties in our Constitution, dear students, you will find that, the 11th fundamental duty under Article 51 capital A, that was introduced by 86th Constitutional Amendment Act of 2002, along with Article 45, under the category of directive principles of state policy, they cast a duty upon the parents and guardians to provide education to their children in the same age group, that is 6 to 14. Article 45 directs the state to provide early childhood care and education to all children until they complete the age of 6 years. This is the mandate of Article 45, that up to the age of 6 years, state has to provide early childhood care and education to all children until they complete the age of 6 years, and after 6 to 14 it becomes their fundamental right that they should get their right to education. This Right to Education Act 2009 makes education a fundamental right of every child between ages of 6 to 14 and specifies minimum norms in elementary schools. It requires all private schools to reserve 25% of seats to children to be reimbursed by the state as part of public-private partnership plan, and kids are admitted in private schools also based on their economic status or caste-based reservations. This act also prohibits all unrecognized schools from practicing and making provision for no donation or capitation fees and no interview of the child or parent for admission in a school. See the beauty of the act. It prohibits all unrecognized schools from practicing and making provisions for donation. You cannot accept donation for admission in any school. Or another form of donation is capitation fee, is not to be charged. No interview of the child. How a small child can give you interview for admission? So indirectly, the schools started taking interview of parents before admission of their child in a particular school. So this interview of child as well as interview of parents both are prohibited under this act, because on the basis of interview you can reject few students, whereas it is the fundamental right of each and every child in the age group of 6 to 14, and it is his fundamental right to receive education. So no question of donation, no question of capitation fees, no question of interview of child, no question of interview of parents, so that each and every child gets his due fundamental right. And dear students, this act also provides that no child shall be held back, expelled, or required to pass a board examination until completion of elementary education. Up to the age of 14 years, no child shall be held back in a previous class. He shall not be expelled from the class. He shall not be required to pass a board examination. And there is also a provision for special training of schools dropout cases to bring them at par with the students of the same age group. If some student has left the school, is a dropout case, then he must be brought back to the school so that he may remain at par with the students of same age group. This is also part of fundamental right to education, that a dropout child has to be brought back to the school so that he may enjoy his fundamental right to education. And dear students, it is to be noted that this right to education act is not new. The universal adult franchise in the act was opposed since most of the population was illiterate. There was an idea with the central government that there should be universal adult franchise. All adults should be universally educated. But this was opposed by many sections of the society because most of the population was illiterate and it was very difficult to give universal adult franchise to everyone. Now coming back to Article 45, which is one of the directive principles of state policy in the Constitution of India. This article provides that state shall endeavor to provide within a period of 10 years from the commencement of this constitution, that is 10 years to be counted from 26 January 1950. So up to 26 January 1960, the state shall endeavor to provide free and compulsory education to all children until they complete the age of 14 years. This was a directive principle which has now been converted into a fundamental right. So there is a transposition of directive principles into fundamental rights. Then, dear students, the important constitutional amendment is 86th Constitutional Amendment Act 2002, which inserted Article 21 capital A, that is right to education, in the Constitution, establishing education as a fundamental right. Article 21 capital A stipulates that state shall provide free and compulsory education to all children of the age group between 6 to 14 years in such a manner as the state may by law determine. State has to pass a legislation, and now the state has passed a legislation, RTE Act 2009. And dear students, as all of you know, that education is an item which is mentioned in the concurrent list of shared subjects in 7th schedule of our constitution. Because education is in the concurrent list, so it enables both the central government and individual states to regulate education by enacting their own laws. Prior to insertion of Article 21 capital A in our constitution, the Supreme Court of India held in 1992 that right to education was a fundamental right that flowed from Article 21 concerning the right to life. If I have a right to life, I have a right to education also. There's another leading judgment, Bachaavandolan versus Union of India. Bachpan Bachao is an NGO who filed writ petition in the Supreme Court for protection of right to education. In this case, Supreme Court stated that the right of children to free and compulsory education has been made a fundamental right under Article 21 capital A of Constitution, and now every child of the age of 6 to 14 years has a right to have free education in neighborhood school till elementary education. So up to the age of 14 years, every child has a right to elementary education in a neighborhood school. Then you see in 2009, as we have discussed earlier also, the right of children to free and compulsory education, RTE Act, was passed as enabling legislation to implement the recently added fundamental right to education. Both the constitutional amendment and this RTE Act came into force on 1st April 2010. And this act requires that every child between ages of 6 and 14 years, including the disadvantaged and low income group children, have the right to free and compulsory education in a neighborhood school till the completion of his or her elementary education. Even the scheduled castes, scheduled tribes, and low income groups and other disadvantaged or weaker groups are to be provided free and compulsory elementary education for them. This act also has made provisions for non-admitted children to be admitted to an age-appropriate class. Suppose a child of 12 years has not yet joined the school. So that child of 12 years age has to be admitted in the corresponding class in which other students of age group of 12 are studying. A very beautiful provision for non-admitted children to be admitted in age-appropriate class. And this act specifies the duties and responsibilities of appropriate government, local authority, and parents in providing free and compulsory education and sharing of financial and other responsibilities between the central and state governments. Moreover, dear students, under section 12 clause C of this act, RTE Act, unaided private schools are required to reserve 25% of their seats for children belonging to scheduled castes, scheduled tribes, and other weaker sections of the society, so that these weaker sections of the society may not be deprived of their fundamental right to education. We have another very important judgment in which the constitutional validity of RTE Act 2009 was challenged. The name of the case is Society for Unaided Private Schools of Rajasthan versus Union of India. Writ petition number is C95 of 2010, decided in 2012. Supreme Court upheld the constitutional validity of RTE Act, Right to Education Act, including Section 12C, but held at the same time that Right to Education Act could not require private minority schools to fulfill 25% quota, as this would violate the right of minority groups to establish private schools under Article 30 of Indian Constitution. So minority schools, the schools managed by minority institutions, were exempted from reserving 25% seats. Remaining all private schools are required to reserve 25% seats for scheduled caste, scheduled tribe, and other weaker sections of the society, so that they may also exercise their right to education in a true sense. Then we have Mohini Jain's decision, Mohini Jain versus State of Karnataka. In this case also, the Supreme Court said that right to education flows directly from right to life under Article 21. This is 1992 judgment. Supreme Court held that right to life is the compendious expression of all those rights which the court must enforce because they are basic to the dignified enjoyment of life. It extends to the full range of conduct which the individual is free to pursue. And they said that right to education flows directly from right to life. The right to life under Article 21 and dignity of an individual cannot be assured unless it is accompanied by right to education. The state government at the same time is under an obligation to make endeavor to provide educational facilities at all levels to its citizens. A beautiful judgment given by the Supreme Court. And this Mohini Jain's decision and its ratio decidendi was partly upheld by the Supreme Court in Unikrishnan and others versus State of Andhra Pradesh. Here the Supreme Court held that the citizens of this country have a fundamental right to education, and the said right flows from Article 21. This right is, however, not an absolute right. Its content and parameters have to be determined in the light of Article 45 and 41 of our Constitution, dealing with directive principles of state policy. In other words, every child, every citizen of this country has a right to free education until he or she completes the age of 14 years. Thereafter, his right to education is subject to limits of economic capacity and development of the respective states. So, dear students, this is all about the Right to Education and Right to Education Act of 2009. Thank you very much. God bless you all.